May I please your Lordship?
Oh, come on. Okay.
I beg to mention item number 2, Lordship. That is India's Minister M. Hassan is out of position for medical purpose.
Okay, John for 2 weeks has prayed for bail and counsel for the appellant. Item 2, amicus curiae is absent. Okay, on behalf of by Mr. A. Hassan, learned counsel on behalf of Mr. N. Hassan, amicus curiae.
DPM.
Yes. Other matters will be adjourned. We are taking up a partner matter.
Item 7 to 19. Part heard.
Mr. Das, just one or two things. This W. Noren Singh, his accused number?
Yes, sir, Imal.
No, Noren Singh, W. Noren Singh, criminal appeal 265.
Yeah, I'll just-
His accused number?
W. Norris Singh Malot, he is accused number 8,
8.
and criminal appeal number 265, 2007.
Yes. This Brojo Bridhu Singh,
W. Noren Singh.
criminal appeal 291. Brojo Bidhu Singh.
Project 291, yeah. The Project Bidu. He's on defense setting.
No, his accused number?
He is accused number 24.
24. No, there are some gaps in my notes. That's why I'm filling it up. And yes, that's all.
Yesterday, about to complete this Jiten Singh Mala. You all also remember Mala. And while Mala, we were reading PW 79.
Dasi. Sleep asli jo kali. Yes. Just a moment, I'll get my notes. Yes. Inside. But please continue, we'll understand. Please continue, because my brother has his notes.
What happened, Mala? Just a recollection. We were discussing about the exhibit of PW 79, and there exhibit 185 euro certificate.
Yes.
Then my submission was that while placing that document before the trial court, no objection was taken. And it went on record. Your Lordship has then said, why not? That objection can be taken in the appeal. My submission was that no. It is not permissible since objection was not taken in at a stage when that document was introduced before the trial court, it cannot be raised in appeal.
Yes.
No, the answer to that, my lord, if your lordship accept, yes, yes, objection was not becoming, then it cannot be raised in appeal. If your lordship has any doubt, they are decision to that. Replace the decision. My lord, one is 2017 8 SCC 570, paragraph 26,
2007, 8 SCC,
2017 8 SCC 570, paragraph 26. And another one, Malad, because it relied, this decision relied on an earlier judgment, Malad, AAR 1965 SC 277. Now,
one 85. Last exhibit. We discussed. This is in relation that the document is not missing. 65. What is the other judgment? 19?
Other judgment is my lord. AR 1965 SC 277, paragraph 6.
277 we are not getting.
That,
1967,
No.
65,
not
1965.
AR 1965 SC
Okay, okay,
65 SC 277.
okay. Open this. Just click the button. Switch on button. Switch on button. Ah. Ah. Listen.
Paragraph 6.
Original.
What is it? What is it? It off. Who's listening? It will not. Para 6 would mean nothing.
6. But that is the maximum. That is the maximum. I'll just quote you from.
That is para 7 in SCC.
My lord, by relying on this to this, my lord, what I would submit, my lord, that exhibit 185, the certificate given by the my lord, protected witness PW80, my lord, he was not examined, but he was placed by 79, PW79. That is, my lord, the document is not in itself is inadmissible, but the mode of proof put forward is irregular or insufficient. It is essential that objection should have been taken at the trial before the document is marked as an exhibit and admitted to the record. A party cannot lie by until the case comes before the court of appeal and then complain for the first time in the mode of proof. Thank you. So অৰ্ডাৰবোৰ উলিয়াব যে নহ'লে পূজা কৰিব অৰ্ডাৰবোৰ উলিয়াই দিব। So Malone, do you have to, Malone, do I have to read the context one? Malone, ordinarily, and I'm taking, reading 2017, 8 HCD, factor and zero, paragraph 22. Ordinarily, an objection to the admissibility of the evidence of evidence to be taken when it is rendered and not subsequent. The objection is to the admissibility of document in evidence may be classified into two classes. An objection that the document is not to be proved is itself inadmissible in evidence. Where the objection does not dispute, the admissibility of document in evidence, but is directed towards the mode of proof, alleging the same to be irregular or insufficient. In the first case, mainly because the document has been marked as exhibit, an objection as to its admissibility is not excluded and is available to be raised even at a later stage or even in appeal or revision. In the latter case, the objection should be taken before the evidence is tendered, and once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. The latter proposition is a rule of fair play. The crucial test is whether an objection, if taken at the appropriate point of time, would have enabled the party tendering the evidence to cure the defect and resort to such mode of proof as would be relevant. The omission to object becomes fatal because by his failure, the party entitled to object allows the party tendering the evidence to act as an assumption that the opposite party is not serious about the mode of proof. On the other hand, a prompt objection does not prejudice the party tendering the evidence for two reasons. Firstly, it enables the court to apply its mind and pronounce its decision on the question of efficiency and then there. And secondly, in the event of finding of the court on a mode of proof not to be adopted, going against the party tendering the evidence, the opportunity of seeking indulgence of the court for permitting a regular mode or method of proof, and thereby removing the objection raised by the opposite party is available to the party leading the evidence. Leading the evidence. Such practice and procedure is fair to both the parties. Out of the two types of objection referred to here above, in the latter case, a failure to raise a prompt and timely objection amounts to waiver of the necessity of for insisting on formal proof of a document. The document itself, which is sought to be proved, being admissible in evidence. In the first case, acquiescence would be no bar, raising the objection in Supreme Court. Now, my lord, here, one eighty-five, exhibit 185, my lord. Is a document, my lord, that is ordinarily admissible in it. The only question that comes, it was executed by PW 79 instead of 80. He who ought to have exhibited it. Now, if your lordship would come to the cross examination part of 79, my lord, possibly your lordship has already gone through it many times, my lord. In this cross examination part of PW 79, no objection, or in the chief also, when this exhibit 185 was introduced, generally whatever when an exhibit is introduced, my lord, in bracket, the court put it under objection. That is an objection, my lord, is put. Here, 185 goes without any objection. So this document cannot be raised, my submission cannot be raised in appeal. Now, summarizing, my lord, the appeal of Jitan
করে দিবেন। 2001 6 SCC 71
2001 6671.
That's good.
14. Paragraph 14. Just enlarge this. It's too small. Font, enlarge the font. The font is too small. You'll have to enlarge it. One font. One. In the middle, after question mark.
In the middle, after question mark, non-examination of material witness is again not a mathematical formula for discarding the weight of a testimony evidence record. Howsoever natural, trustworthy, and convincing it may be, the charge of withholding a material witness from the court leveled against the prosecution should be examined in the background of facts and circumstances of each case so as to find out whether the witnesses were available for being examined by the court and yet were withheld by the prosecution. Only that much. This is in essence the query. Yes.
Hello.
Mr. Prasad, uh, one argument was made by Mr. Mishra that the uh, with regard to that loan, one of the one of the evidence of the witnesses was wrongly recorded in the judgment. I forgot to note that PW whose evidence was wrongly read. So please find out that in the meantime.
My lord. Well. Let's see. Why not?
So this is over.
No, just one sentence, my lord. My submission is that, my lord. Now, what are the evidence that were put before the court, trial court? Or that is oral evidence, my lord, one part. That itself is sufficient to show Jiten Singh is a member of UNLF and his conviction under section 20 is justified. Next, if we accept for tribunal, let us accept the uh, what you call email where his name appears as Lieutenant Colonel in the officers list as well as his phone appearance. For the time, let us accept it as true because I will make a address this point in the third whole year together, Mala, regarding agent. Let us accept it as correct. Why this itself, Malat, is proved under section 18 and 121A. That's my submission. So, this, now, Malad, may I take your lordship to another we come to PW 23, PW 23, PW 24. Cái này. Over here. Đúng rồi. Rồi. Ra tạo ra đoạn. Đây đọc vào đây.
Thousand 17, 8 SCC, 570. 26. Twenty-seven here. This is on what you are lying.
No,
relying on
Maharaj, paragraph is wrong. Maharaj, it will be down below. Paragraph. Here,
29?
Yeah, where, 29, 29.
So you see now, this is being divided, admissibility and as well as the mode. Supreme Court is devising two things. Correct. Now, where the objection is taken, so and so, and thereafter you see it, it comes to the effect of overrule 31 or 32, come to 31 and 32.
In this case, the first line of the
Hmm.
this was different.
Admitted admissibility difference.
But in this, our present case of electronic evidence, email are not at all admissible.
So here you see this CDR was admitted without certificate. Now come down again.
Those who want to pursue inadmissible certificate, because there is a writer without certificate cannot be.
Come below again. More below. Come down. Yes, the effect of overrule. This is something, thus, this is something you'll have to address us. Because here distinction is carved out.
No, that is why I said, Malad, this judgment, Malad, it refers to two part.
No, our case is decided after Anwar. Here you see this is very relevant because it says pre-Anwar and post-Anwar.
But no, no, Malad, here, your lordship is right looking into pre-Anwar and post-Anwar. That is a different. I have referred this as only with regard to admissibility order.
No, but you see this in the same judgment, it has been discussed how to treat that.
Exactly. How to treat that? Now, it is said that this CDR or electronic evidence, there is another without certificate query. That's a precondition.
No. You see, in this case, that's why we are again telling you this effect of overrule will be very important in your case. It will be very crucial. This judgment has to be read as a whole, not one paragraph.
Yeah.
So the paragraph 26, 27 we are relying on must be read in consonance with the other paragraphs. You'll have to address us, not today, tomorrow, but you'll have to address us on this.
We'll say that.
You go through it again. Because there is a catch here.
Yeah, Pilan may have Appellant more interested.
Mr. Prasad, you will also be addressing us on this, because this either takes away your case or demolishes the case of the prosecution.
So, this, our case is of 2011. And Anwar, I think 2014. And later, the other husband, Malak, 2022 or 20. Yeah, 2022, Malak, the other husband. Now, all these husbands are to be read prospectively.
That is what is explained here.
Come on,
But you see, there is again a catch. We'll tell you why.
that's what I'll be
This,
submitting. Malak.
this PW, this document was exhibited by whom?
This one 79, Malak, 185.
PW 79. PW 79 is part 1.
Malak, that is below 70, part 2, or part 1, volume 2. Page you also will find. 419.
419. Day of examination was 18/8/2015. And this Anwar was decided on
14, Malak, 2014.
18/9/2014.
2014. And our search sheet was filed.
No,
2011.
it's not a question of charge sheet.
Ah.
You see, the rule will apply prospectively. Then also Anwar comes in 2014.
2014, yeah.
This witness was examined in 2015. Therefore, we said, the prospective overruling, please read that and we address us on that on the next date. You're not saying do it today. You be comfortable and do it any other day.
Now, coming to the other case, Malak, that I'll be taking a worship to Jodabidu. And Ibomsa, that can be taken together, Malak. Criminal appeal number 291, 2016. Rosovito. Thing. Accused number 24. Then criminal appeal number 295, 2016. A. Ibomsa. Accused number 25. Uh, section 20 and 21. Malak. Yeah, Bojovido and the other is A. Ibomsa. A. Ibomsa. Accused number 25. Criminal appeal number 295, 16. Both are the same, same set, Malak, same set of evidence. So, while discussing one evidence, Malak, the other will cover.
Criminal appeal?
Now you're in which case? Criminal appeal?
Criminal appeal 291, 16 and 295.
Braja Bidhu Singh.
Bojovido Singh. Accused number 24.
His accused number,
and the other is
his accused number 24.
29, he is the case number 24. 24.
And second is criminal appeal number
Criminal appeal number 295/16, 2016.
A. Bomcha.
A. Yvonne Cha Singh, accused number 25.
Yes.
Both these accused were charged, convicted under section 20 and 21. 20, and they were sentenced to 7 years both. And fine of rupees 20,000. Here. Here also oral evidence. Supported by electronic evidence. Now, since your lordship has gone, a number of times to this evidence, my lord, I'll just bring a picture. What happened, my lord? There is Aegis, that is a food processing company, my lord. These, both these accused, they were functioning, the functionaries were the executive member or president, etc. and all. We'll come to that in details. Now. Without looking into the evidence, Madam, the picture is that because in the supplementary searches, they were charged. Same case, that is Nurmati case, they were all these 1 to 18 were arrested here, 19 were arrested here. Then, with the permission of the code, 173(8), Madam, the supplementary search was. And these two, 6 accused were there, 3 were absconded, and 3 were arrested and yes. Now, during evidence, what they found out that all the extorted money they were put in this account. And that is how this is how when CA was while CA was examining their papers, they said that you bring the papers who has contributed, etc. about 8 lakhs or 10 lakhs or little something more that will come to that. But they could not bring it. Now, what has happened, Mother? The another factor is that after their accounting, etc., whatever it is, Balot, they used to bring this to Guwahati, sit down in a hotel where they didn't say some members, they inspected the documents, etc. We just stop it here, Balot. That by itself doesn't show anything that they are members. Now, when the emails, etc., were downloaded, Malot, a number of documents, Malot, they were found, all the accounting, etc., has gone to the mail of the chairman, etc., and all things that they were looking at. That is how we say that this firm is controlled by UNLF. Now here, Malot, this the argument from the defense side was placed by DK Mishra Malot. That is a society accept, all accepted Malot. That is all world. That they got central fund, etc., all etc. Nothing to do with that Malot. Now, we are basically on with this area Malot, that this unit was going on and the extorted money was put in just to legalize it. And from the opposition side to support it, we say the accounting, etc., has was looked by members of the UNLF at Guwahati, as well as because nobody has spelled out that who has looked it, they are members of the UNLF. But we have to infer that Malot by looking into the emails Malot. That is our limited argument in this case. Now, you also will come to PW 23-24. You all also has already gone through it. Will be very short, Malot. 23 at page 222, 222, okay. 222. This evidence, Malot, it only says that AGIS, Association for Extensive Growers Innovative, Malot. We will not go into that. It's a registered firm, no dispute about it. Then Y Bijbudu, he is a secretary, Malot, and Bomi Singh, he is not before lordship. He was and Ivam Singh. Treasurer Ivam Singh. President Y Bijbudu. He was the president Y Bijbudu. The first paragraph, Malot, he says about in the account opening form in the bank, Malot, Y Bijbudu is shown as president and A Vamsa as treasurer, Malot. We'll leave to it, that is correct. Then AG applied for loan of 50 lakhs. 3705 against 3-term deposit, of which the party submitted into the bank for 25 lakhs, 20 lakhs, and 20 lakhs. And in all, total 65 lakhs for securing the loan. The party thereafter repaid the full amount of loan of 16/8/2005 by adjusting the term deposit within a period of 14 days. Exhibit 50 is a loan statement for the period so and so so and so. Exhibit 51 is a loan sanction letter. So and so so. Exhibit 51 is a continuing letter. Then we leave this 50. 53, 7 hours of pay in slip deposit so and so so and so. No trouble at all, matter. The only it shows that for a period of about 15 days or so, and this loan was shown to be taken. There is a term deposit. At that time, Cross-Muller, at the time of loan transaction, which I mentioned in my examination chief, I was not at administrative for the bank. As I was working as manager of the so-and-so bank, one L. Singh was a general manager of the bank. The said L. Singh died about one.
Just a moment.
Please, please. Right.
Yes.
Hello. So, Pillar 23, it only says that loan was taken, which was not necessary at all, and was repaid. That's all. Nothing else. Because that is the only evidence we regard that. Yeah.
Because this is something which I did when I was in that side.
But
I used to bank there. Now you see, and I can assure you that every bank does it. If you give your fixed deposit to a bank, every bank without any questions will give you 90% of the loan. Now here the parties gave 65 lakh rupees as fixed deposit security to the bank, and loan is 50 lakh rupees. So it is they are in fact giving less than what is envisaged. 90% no question asked, and the interest charge is 2% more than the lending rate. So so
the only thing is
you have a fixed deposit, you have a loan,
Hello.
and then you don't have to break your fixed
now
deposit
fixed deposit.
for money. So at times when funds were scarce, you could take an overdraft from our own fixed deposit and manage my affairs. And when flow came in, it was repaid, and then uh, we had it. So,
Understand. That is done.
but this is something I did.
That is done.
Now, after coming here, there was no requirement, so I closed that account. And the account number was very unique. I will remember it always.
Interest is more than the fixed deposit, term deposit. Interest,
It is 2% more. So
2%.
if I'm getting 7.5%, and if I take a loan, I would have to pay 2%.
2%.
That means I don't earn at that time, and I pay 2%. So I had easy access of money at 2%.
Now, we come to the next witness model. PW 24 at page 224. Pillar 24, Mala. Page 2 to 4. I'm reading from the second paragraph, Mala.
Yes.
Among the clients, we also had Association for Extensive Growers Innovative Service as our client, and the firm had audited their accounts in the year 2005, 6, 2006, 7, and 2007, 8. The firm would produce the documents and books of account, and for that purpose, their secretary and Bhumi Singh also came to our office. On behalf of the firm, I also visited AGs at Matripuri Imphal for the purpose of verifying, and I found that one of the machines was installed and the workshop was under construction. The accountant, after production, used to take back the books of account and other documents, and I found that some of the contributions were not supported by proper documents. And I advise that the same transaction should be through, through bank with proper receipt and should be supported by bank statement. I also, I also noticed that there were loans of bigger amount taken by the firm, but I found that the bank statement does not reflect repayment of the loan. After my advice, agents did not come to our firm after 2008. As such, I cannot say how they have managed the firm. Then he goes, Exhibit 55 are the set of documents which the party submitted in the course of auditing. Is a CJ memo, so and so. Then statement, so and so, 56 is a Caesar memo by which
No.
part two, part one, part two, page 2 for 1. Two for
Last.
It's very difficult to follow the evidence of prosecution. You see, this PW 24 comes and says that they took loan. Bank statement does not say, does not reflect repayment. Now, supposing I take a loan from my brother of rupees 10. In my accounts, I have shown it. I have not returned it. I have not returned to my brother. So there is an outstanding shown in the accounts. If any person is aggrieved, it will be my brother, not anybody else. That's one part. Second part is that in this evidence at page 24, reference is made to exhibit 55. In that page 55, bank account document is not even seized. So therefore, it's just like saying, presenting a new, presenting 1 month newspaper and saying that in one of the newspapers, there's an evidence of defamation against me.
Understand? But here,
But you see, somebody is making a statement about the loan. And that part of the evidence is not even there.
exhibit.
Loan taken, that itself is not there. Repayment, okay, we accept, loan is not repaid. So this manager will lose service if he has given loan without document. And that is not the allegation that the loan was taken in a dubious manner. We are now examining an investigation where because of this transaction, somebody is said to be a terrorist. Now, if the loan is taken, loan is not paid, one doesn't become a terrorist. Well, 3 of our good gentlemen are now in UK. They have taken loan and they are now in UK. Huge amount of loan, but they are not terrorists.
That is question, Bala.
No, you
That-
see,
no.
it must come to a logical conclusion. Number one,
But we don't conclude from this evidence alone that they are terrorists or they are member of PWD. We will conclude it after looking at the emails.
no, it's okay, but something must match.
But this evidence
Because
was-
you see, maybe your assisting counsel, somebody came to her today morning, asked for an affidavit. She said, I'll charge 1,000. And outside the client is heard saying, she is extorting money. Correct?
Right.
But that itself, charging of fees, taking of remuneration by a lawyer, and utterances by a client, the lawyer is extorting money, would not make it extortion.
By itself, of course.
By itself, you see, we are once we are evaluating our evidence value of PW 24, we don't find anything.
No, here you also find one thing. That the series under construction, only one machine is there. One factor. And you'll just keep your logic in mind. And we'll go to the tax unit. That is under what they are producing, etc. and all things, how they are viable, etc. Next, we will go to Malad. We just ended here, Malad. We go to page 29. That is 238 page number. There's below 29 page 238. Same volume. Here also we don't get nothing much. Pillar 29, at page 238.
Yes.
But, I joined this with a newly established industry. I was allotted the duty to assist and supervise the work AGs. In AGs, I came to know one Harida Sharma, the time president AGs, and promising secretary AGs, and Y. Vijay Singh, executive member, and others. I also came to know that in the running of the AGs, they used to take loan from IUCB, AEUCB, that is Bank Impal, and SFSC and Ministry of Food Processing Industry. In the year 2008, I met with several while I was working, then I was bedridden for about a month and I could not attain my duties and I resigned from AGS in the same year. while I was working, I was not getting my regular salary. Presently, I have started my own business. I came to know that a police officer, he produced certain documents. His evidence is only one of that he has given the name of the accused person, that is one factor. Then, and he has produced certain documents. That is his evidence. We'll go to the evidence, after completing PW 43, at a time we'll just go. That, they 29. Volume two. I will not. Below 43, at page 273, you will also find this at volume 2, paper volume 2, part 1, volume 2. এটা কি হয়েছে 193 exit 193 is 193. I worked as Director of Agriculture of the Government of Manipur and I retired in the year 2000. After my retirement, I joined a private firm called Association of Executive Extensive Growers Innovative Service, AGS. The said farm is a registered society and it works for fruit processing plant. The said farm is at Impal East. Initially, I started with extraction of fruit juices. I joined as president of executive president of executive committee of the society. I worked in the said society till it was closed by NIA. There was an instance of telling me that my promotion from joint director to additional director of agriculture by superseding a few seniors while I was in FCI. Although the post belongs to the state government, some youth came and asked me not to accept the promotion. They even shown indication that they have arms and with them. I told the youth that my promotion is not done by myself, but by the higher authority. NSA AGs
No, no, you continue this part.
To continue this part,
Initially, AGs started from Purana Rajbari, which is also in Imphal. Before my becoming president, Aziz Wajabitu was the president and Bombay Singh secretary, and he continued as such and treasurer Ibom Singh. When I just entered as president, the initial capital of Aziz was estimated to be 197 lakhs and later revised to 206 lakhs. 206 lakhs. An amount of rupees 50 lakhs was taken from Imphal Urban Cooperative Bank main branch, but the same was not utilized and was deposited back within a short period. During the taking of loan from the bank, Rajavito Singh was the president. During 2005, I came to Guwahati to meet the consultant of the project in connection with the AGs. It was discussed where I met Secretary N. Bomay Singh, Rajavito, A. Bomson Singh, and some others which I do not remember. There, the person whom I met was not known to me, but he asked regarding the viability of the project, to which I replied, it is going well. After my return to Impala, I continued as president. I again came to Guwahati sometime in 2009 and stayed in a hotel. During that time also, Bajivjit Singh and Ibom came to Guwahati and Bomay Singh did not come because of his illness. During my stay in the hotel, we all met another person and simply inquired about the project of AGS. Why Bijutu is related to member of UNL. During investigation, my statement was recorded before Magistrate First Class. So and so. Exhibit 93 is a said section 164 statement. Exhibit 100 so and so so and so. 94 is the attachment notice.
Just before we take a break, I was trying to explain to my brother what has happened. I believe you have some experience in business. No,
Right now.
no, you have any background experience
No,
in
no, no.
business? No. You come to page 274.
Page 274,
Yes. Now, before that, 273 you were reading.
Yeah.
273, last paragraph.
273 last paragraph.
Yes. Just when I entered as president, the initial capital of so and so was once a 97 lakh and later revised to 206 lakh. Correct? You've seen that? Now come to cross examination. AG is a society registered under so and so, project to the so and so, seeking funds to the AIGs. Under the said project, we sought financial assistance from of 206 lakh. On approval of our project, the Ministry of Agriculture so and so allotted sanction so and released the same in favor of Aegis. Another sum of so and so was also sanctioned and released by the Food Ministry of Food Processing, Government of India in favor of so and so. The said amount of rupees 28 was a long-term loan, and the sum of 56 was a purely a grant. Correct? Now we stop here for the time being. Now, you see the what do you call? That is why this loan is taken. Amount inflated of their requirement, because you see, we don't have that scheme. Incidentally, the NIA did not seize the scheme of government grant. Now, I have checked up the percentages. The government grant and loan of the project cost amounted to 72.88%. Correct. So it's an agriculture project. So government says that if you have this much of money, we will give you this much of grant. And therefore they take a loan, have that amount, grant comes. It is your witness who is saying money has come and then the loan is returned. Now, this is one part. There is a second aspect. Have you ever seen in your litigation life PWD F2 form of contract? You have read it? PWD, Assam PWD agreement is made in F2 form. You have read it anytime?
Just have to kind of recollect now.
Okay.
Yeah.
If you care to read that F2 form of contract, then you will find that the value of contract, supposing the value of contract is 10 lakh rupees. Under the F2 form of contract, there's a requirement that you will have a bank account and take a loan of 10 lakh rupees, and then you are granted this work.
Yeah.
That means your liquidity must be there. So government requires that a bank
Viability.
for viability, that you take a bank loan and then we give you this amount. So you see, I have some experience in because of the background community I belong to. We know many things, especially when it comes to business. I may not know anything else, but this is something which we are dealing with. And now, therefore, you see, this loan. Then I showed you this Bank of Baroda. Against FD, without question, they can any bank can give you a loan. And then this government grant. Now this grant, incidentally, we have calculated. Out of 206, your witness is giving a description of 150 lakh, which is coming from the government.
Yes.
Correct.
Yeah.
Amount is 28 lakh, 56 lakhs, and again 56 lakh. So it comes to 150 lakh.
Yeah.
So your terrorism vanishes.
Oh my God.
Yes, yes. Because it did this dedication, therefore I am aware.
Let me uh, the exhibit that was exhibited by PWD 43. Let me show you. Exhibit. 94. Hello, that is, part 2, volume 5, exhibit 93. These are the account statements, but 93, 12, no, it was 12. From 19 to 12. Page 1039. 1040. 1041. 1042. Up to earlier part is the account statement which we always will, but the other part, Maran, that you always will find from page 1039 to 1040. Are performed is equals number 9, yeah, 18, salary@yahoo.com.
I'm sorry, I'm not following you. Page 1039.
1039. 1039. Your exhibit 93 by 12, my lord. This document was retrieved from the mail of accused number 18. Selected. Eighteen 94 by 94 12 and 94. It okay, 12, 13. Okay, 183 by kiman?
193 by 12.
Or is kiman?
No, 11. 11.
Yeah.
11. 193 by 11.
11. 12.
194. 1. 1.
Can I have one? 3.
3. Oh. 11 too.
This is,
This page 1039 is proved by whom?
1039.
It is proved by whom?
Or that is, it has gone from, I don't know.
Because this is not by PW 43. 43 did not prove this.
43. No. No, no, you're right, Madam. You're also right. Not 43. That is. You're also right. Somebody else, Madam. Yeah, we'll come to that, Madam. I don't know. 10. Will. Not 43, Madam. I'm not sure. Madam, in the cross-examination portion of PW 43, Madam, at page 275, Madam. After recording my statement by magistrate, I was escorted back to my hotel by state police officer arrangement. The witness is confronted with the portion of his statement recorded under 164 CRPC. Running with a board, now in 2011, I came to know that all these supposed named 3 people have linked with UNLF and they invested money of this UNLF into our food purchase scheme of AGs. And the witness was asked whether he gave us portion of statement before the magistrate or not. I did not actually say the said portion of statement to the magistrate. I cannot remember if the statement under section 160 was read over to me by magistrate or not. I do not know the name of it. Well, no. Magistrate was examined in this case, Madam. Is এগুলি করে নাই আর কি করলাম
PW 43.
এগুলি তো এগুলি করা নাই এগুলি করা নাই
90.
না টেস্ট পজিশন কি এটা পজিশন কিন্তু এই তো আমি পরিচয় তোমার হেডি 43 এখন লিখে নিই Exhibit one,
It was
96.
Yeah, for 96. Itulah.
Seven five. Eight. This is eight. My lord, coming to exhibit 96 at paper part 2, volume 2, my lord. Page 375.
No, just a moment, this PW, we were earlier at PW 43 or 53.
PW 43.
No, last we were in PW 43, then you referred to page 1039. So we close it for the time being.
PW 43, my lord. PW 43, he exhibited 96.
96. So this 1043, we close it, 1039, we close it down. This 1039,
1, 2, 3. Yes, my lord.
okay,
that-
okay. Yes. Now which page? PW
PW 43.
375, okay.
43, 375. Paperwork part 2, volume 2.
Page 375
375.
is part of PW 71.
No. 370 paper.
Oh, part two. Oh, I'm sorry.
Have you got the exhibit?
Okay,
My
okay.
base, my lord. You must be-
No, I'm sorry, I was looking at part one,
Uh,
300,
370.
this
75,
part 2, volume 2.
75.
Part 2, volume
Yes.
So this is the account statement, Mala. Yeah, you also will find members contribution where the CA has taken objection is 8 lakhs, Mala. That was not supported by documents. That is what he has said. At page 375, exhibit 96, Mala.
You see,
These things are quite possible.
Yeah.
Because you see, when we are what do you call examining the case of terrorism, you see few lakh rupees here and there, unaccountable money. That won't create an impact because we will tell you why. Now, today morning before sitting, I gave a requisition to my court master that I would be requiring to note 3 pencils. So he has purchased a packet of 10 pencils, and out of that, these 3 pencils they have provided.
Mala.
Correct. Now, it's quite possible that while reading, writing, I forget and I take 1 pencil when I go out. And in the at 1 o'clock, when there is a asset reconciliation, then maybe it's possible that out of 3, 1 is missing. But doesn't prove anything. It doesn't prove that there is a theft. It doesn't prove that there is a loss of asset. Because if at 2 o'clock when I come, this pen will come again, pencil will come again. So you see, lack of reconciliation doesn't lead to an inference that it is a case of theft, it is a case of terrorism, it's a case of what do you call siphoning of assets. It doesn't prove that. But that's why I gave you that example of 5 days ago. 174 crore rupees tax was deposited. You have checked it? No.
No, Mala. With, but with regard to that, Mala, the only supporting is that they bring all the account statement to Guwahati and is seen by some person. And that some person we say they are the
No, we'll tell you why. You see, if you come to Income Tax Act, 267 or 269 SS, just give the Income Tax Act. 269 SS requires that when something is given to a company by way of a loan or something, that must be by way of a check under the Income Tax Act. So therefore, when a chartered accountant makes a what you call examines an entry with regard to cash receipt, he will say that for a company it is improper. You get us documents. Yes, I am at 269 SS at this.
a mode of taking loan.
So therefore, you see what happens is that in this balance sheet, while you had placed before us, we had examined this already. You will please come to page 379 now. You are there, 379. Last item 6, unsecured loan is 9.30 lakh. See, in this 9.30 lakh, if you are a chartered accountant and you see the entries and you don't find that it is backed by required document of 269 SS, definitely as an auditor, you will say that this is not correct. But that doesn't mean that unsecured loan of 9.30 is not there. Correct. And there's a second aspect. Page 375.
Yes. Yes.
Yes, you see the receipts. Members' contribution, so and so, unsecured loan from friends and relatives. They are mentioned. And then you see, you come to this page 379 again. Now you will find project cost is assessed at rupees 206.64 crore, a lakh.
Yeah.
So this is tallying with the project cost which you showed from the evidence of PW 53.
Yeah.
So you see, yesterday also I gave you an example, not yesterday, day before yesterday. You see, today when I have come out from my home, I don't know exactly what amount of money is there in my purse. But at night when I went, I counted the money in the purse and I'm aware that in my purse there is 100 rupees. But in morning when I came up, I did not check it. So maybe yesterday's closing balance may not tally with today's opening balance. But that doesn't mean that is money went to some unscrupulous hands. Maybe it is quite possible that today half a kilo of potato was required and my wife picked up 10 rupees from there to pay for half a kilo of potato. So therefore, yesterday's closing balance and today's opening balance may not tally. So in accounts, you don't find anything unless you show us something.
That is it, Madam. We'll put it towards exhibits, Madam, where the whole accounting system has gone to UNLF.
Because in my college, I had management accountancy and taxation as a subject.
Question is, now, question is, unless one is interested in the business, why the account would go to them and see and accept it, etc. and all things. That is what will be the question mark.
Pardon me, please.
The whole accounts goes to UNLF in their books of account. That is what we will see, Madam. This AGs, they approved it or they discussed whatever it is. Now, question remains, Madam, that unless UNLF is not there or not interested in the business or whatever, why would they do with their accounts, which they, because that is a question, Madam. That you also will take care.
No, let me pose a question in a different way.
Yes.
You see, every citizen is expected to have an honest income, right? Now, why don't all the balance sheets of all the citizens of the country is uploaded in the website? Let there be an open portal. Income of everybody should be uploaded there. If you have an honest income, why do you have to fear? But why that is not the law? That is because if you upload your balance, maybe today evening there will be a theft in your house. So therefore, what is protected by the government is the income of a citizen. Although the government in the taxation department knows about the income, but still it is not a part of the open platform. And under the Representation of People's Act, there's a requirement under 80, 81 or 86 that the income statement or the asset statement has to be filed along with the with the with this before the election officer, and that is sent to the website. It is because of the transparency which the Supreme Court had directed under PUC case, Public Union of Civil Liberties, where there is a requirement that to show transparency and to show that these politicians are honest, the financial statement are uploaded. The second aspect of it, this accounts, if somebody calls it, now let us say the investigating agency calls for an accounts, or a terrorist organization gives a letter to X, says that now you give your statement of accounts to us. Now what will a citizen do? Officer in charge of a police station gives you a notice. Give us your books of accounts. It's required for investigation. A terrorist organization gives you a letter in the letterhead saying that you give us your statement of account.
Somebody has to say that.
Now the question is that merely because I sent it to them.
They would have frankly said that, yes, we have given it because we were forced to give. That is the end of the matter.
But that question was never asked. That question was never asked. Now you are inferring with that because of the fact that somebody may have an interest, and then you say that they are monitoring this. But this monitoring, evidence of monitoring is not there. Star witnesses, 2 witnesses came who are ex-employees of Aegis. They don't say.
Only by virtue of the email we will just see. That is the problem. Whether you are also accepting it or
No,
not.
no. We are not, you see, mainly by asking a question, we are not saying that we have made up our mind.
But no,
We are eliciting answers to understand the scheme of things.
that is why, Madhav, we say by these 3 witnesses we have. What is
No, but this way we are picking up holes. You see, that's why we showed you 269 SS. Because merely because a chartered accountant says that we don't find it acceptable. We have reasons to say that it is not acceptable. And it doesn't, you see, when a chartered accountant asks that as a student of taxation, it's required to be presented in that manner.
Let us see.
Because we have to go to the bar right now. We'll continue, and we may be 10 minutes late.
I don't know what has happened to Bora now. What has happened to Rakesh Seth and Manipur, I don't know. After all this. Oh, Ram. Madhav, for the timing, let us stop. This, Bajobiro and Ibom Jha. here, only with the oral evidence, of course, I have, court has appreciated, nothing much has come up from oral evidence, my lord. We'll try to supplement it by,
What was that page? I did not note it. What was that page you were referring to?
oh, yeah.
That page I forgot to record.
Page 375.
375. Okay, page 375. My brother has recorded part.
That is.
Yes.
Uh, from all the, all of, PWS mallet that we have placed, mallet. The oral evidence, mallet, as such, nothing has, much has come up, mallet. I should say, only one says that we bring the statement to Guwahati, that's all. He doesn't say who looked, but somebody looks. Let us, as it is, my lord, what the evidence has said, we'll just confine to that. And the statement of accounts that we have seen, my lord, you also have seen, my lord. Only that much, my lord, as the CA has stated, some accounts he has found objection and that it has not been supplemented. Let us stop. No, other matter emails, matter, he has, at least this witness has not proved that. We'll just see it at later stage. So, to sum up this, two accused, matter, 25, 24 and 25, matter. I'll just. Oh, no. Now I'll be taking it to a lordship, my lord, where only one oral evidence are there, my lord, and that I hope will complete it, my lord. That is for Londoni and Moniton. This is, my lord, Londoni and Moniton. And rest three, my lord. I'll complete it tomorrow, my lord. Rest three. Londoni, you also will find, she is a question number 14 and criminal appeal number 16516. Malad, for Londoni, Malad, statement of deposition of PW 17 Malad, MC Arun, only one paragraph Malad, that is relevant. At page 211, paper book part 1, paper part volume part 1, volume 1.
Page number?
Page number 211. Only one paragraph, my lord, the second paragraph. I have three brothers and I am the eldest. The second one named Joyanta Kumar, joined UNLF in the year 1982. Until today, we do not have any touch with him. We have three sisters, the youngest, Londoni, who eloped with Jitan, equity number 10, who is a member of UNLF. As she has eloped, we have boycotted her. That is that is the only three line statement, my lord. One has joined UNLF, his brother, second one, and the youngest daughter, my lord, sister, Londoni, same eloped with Jitan, accused over 10, and the family have no connection with them. That is the only statement. And in the cross-examination matter, nothing have been crossed. Whatever it is, my lord, if they want, nothing is there. That is the whole statement of this. Then your lordship will come to the next statement. Of course, she had turned hostile, and we have examined the magistrate, my lord, that is PW 47 288. At part 1, volume 2, page 288. At page 285, my lord. 288, my lord. I'm not, it is not affected on so and so hours. I visited first MR Imphal in the presence of Lady Constable so and so, sir, and given my statement before the NI officer so and so. I denied the statement that I have got email address so and also address. I also denied that I used to email to converse with my friend acquaintance, namely Suresh Soren, Dina so and so, Jiten, Komba, Opendro, LIC agent, and sister Gitawali. I deny that the email address of Suresh Soren is so and the email address of Jiten Komba is so. I also deny that I know Suresh, who is about 45 years of age, for the last 2-3 years, to Dina, who is the husband of my close friend, namely Londoni Devi. I also deny that I came to know sometime back that both my friend and her husband had been arrested by police. I also denied that I had met Londoni Devi last time at the time of Rath Jatra in July 2010 at Palace compound. I also deny that I am aware that Londoni Devi and her husband were active members of UNLF. It is also denied that I continued my friendship with them as because Londoni was my close friend since childhood and I have nothing to do with real life. I also deny that after introduction of Suresh Soren, your judgment, Londoni is charged only with section 820. Londoni, case number 14, she is charged only with section 20. Nothing. I also deny that after introduction of Suresh Soren by Dina, I have developed close friendship with them and we often used to discuss conditions of Manipur and our well-being. I also deny that since my knowing Suresh Soren, I was aware that he was an active member of UNLF, but I did not care as I had been nothing to do with UNLF. It is, I deny that in December 2009, he rang me up and told me that somebody will come to my house and deposit some money for safekeeping in my house. It is also not true that I was told not to tell the same to anybody. It is also not true that I was also told that some other person will come and collect the said money after his introduction, I think. I also deny that I have suspicion that the said money could be extortion money of UNRWA. I confronted him over phone, to which he threatened that no person in Impal could defy his orders. It is also denied that I was told to do as he directed, otherwise my life would be in danger in the hands of senior members of UNLV. It is denied that I did as told by Suresh, and the first incident was in December 2009, when one person came and deposited money in polythene black in color. The money must have been in lakhs, but I am not sure the exact amount. I also deny that I kept the same in Almira under lock and key. I also deny that probably 1st and 2nd January 2010, a different person came from so and so place for collection. It is also I also deny that after verifying, I had handed over the bundle to him. It is, I deny that on the second occasion, probably on 3rd January 2010, again a person on direction of Suresh came and deposited money in black polythene bag, which I kept in the wooden almirah and lock and key. It is also denied that this time also the money must have been lakhs of rupees. I deny that Suresh became angry with me and I threatened by him to return the said money. I also deny that since then I tried to avoid them. Also deny that I am aware of Suresh Soren. He is presently in jail. I also deny that during my conversation with Suresh Soren, the name of Mr. Ibom Tangma Moniton Singh resident of Assam, Dilip Mani, resident of Manipur, came up as active members of UNLF. Exhibit 103 is the black and white copy of photograph of M. Sarat Suresh Soren, but I cannot identify the person. Exhibit 103 is my signature, but I cannot say when I put. Exhibit 104 is 164 CRP statement recorded on 11/1/2011 by Judicial Magistrate First Class Manipur, but I do not remember as to how I have given to the magistrate. I have one brother namely Gopal Singh, and he is working in press. Today I have come from Impal with my brother Gopal Singh. It is not a fact that because of my friendship with Suresh Soren, Dina Jiten, London Devi, I have deposed falsely before the court. I deny that because of the threat and tutoring by the adversary, I have deposed falsely in the court. I said that I have received threat from the UNL for deposing falsely before the court today. Then, in the close manner, I am a cancer patient. I got my treatment at so and so Mumbai. I have undergone operation in my right side so and so. I have undergone different course of medication therapy so and so. I have received 10 cycles so and so. Then I have to be on regular medical so and so so and so. She said February I could not go for medical checkup for declaration health and due to reaction of caused by radiation and therapies. I have lost most of my past memories. I sometimes recollect my memories intermittently. Exhibit 106 does not contain my signature. That is all. That is all. He only is denied his.
I'm just looking at a particular exhibit.
One of the
Yes, I don't see you.
Number B.
No.
what is the one, my lord? The original case is over, my lord, in NI court, quite long time back. If the original is my lord, as it was placed, these are photocopies. If it is required, that might be call again, my lord.
No, you get us instructions that it is over, we'll get it.
It's over, but I haven't done.
No. I told you yesterday, one of the absconded accused has been arrested.
Yes, that is it. He was arrested, then trial started. And that is what.
Huh.
By judgment, my lord, that is over.
You give us an affidavit, we'll call it.
Do we have to file an application or your lordship may kindly call?
Because then I'll have to record.
Because then I'll have to record your statement and then call it.
that? Because
You see-
maybe the original may be required.
No, we'll get it. We're not saying we'll not get it, but we'll have to record your statement, then call it. Then we record your statement that it is over, then we'll call it again.
We will by verbal.
Verbal will do.
Kitty said, "Japan to Kitty on the Japan." Herbal was disciple দিব এইটো মাতিম পাৰিবা নেকি এইটো মই কলিতা খুটা যাম এই জাজমেণ্ট ডেটেড কিমান এইটো কেইজনৰ কিমান আছিলে
Please do this.
Okay,
Case record.
That is why would no that trick tu asal tu orang hari pasal itu konsep anggobi sama anggobi sama if it dispose of all test number লাগিব হেৰিটো দিয়াচোন কষ্ট কিবা চাইছে নেকি এই হেৰিটো দিয়াচোন volume 2 0.4 part 2 volume 2 part 2 volume 2 402 ইয়াতে পাৰে উপায় মানে suspended final date के बाद आपको बताइए केस नंबर स्पेशल केस नंबर ये एवं अके का शर्मा the matter पर खावा जाना तो है वो स्लिप कंपा कोट स्लिप कंपा तेरे के लिए विशेष केस नंबर तो लिखा एक जना मतलब लिखा
From below. Show me that.
तो जजमेंट तो है ना मुंह ना लगे
30.
Exhibit kata. Exhibit 11570. Part 2 volume 2. Based on- Push up kwa. Kita.
Mr. Das, we're trying to analyze this statement. We are trying to go through exhibits. This exhibit 104 by this witness, she is witness number, she is PW 47, correct? Yes, in page 289, which you were showing it to us. She says, the second last paragraph, exhibit 104 is the 164 PC statement recorded on so and so by judicial magistrate first class. But I do not remember how I have given that to the magistrate.
But I do not.
Correct. Last page, 289. Now in 290, we omit the first part and come to second part. Cross-examination by defense.
Yes.
Here she says that she has received 10 cycles of chemotherapy. And then she says, I could not go for medical examination for my deteriorating health condition due to the reaction caused by radiations and therapies. I have lost most of my past memory. I sometimes recollect my memories intermittently. Exhibit 104 does not contain my signature. Say if 104 statement of the witness before a magistrate does not contain a signature, everything goes. How does it help you?
I don't know how it was recorded. She said so, but we have to see the original one, whether it contains.
No, it doesn't have. It's not exhibited. Because you see, the witness will say 104 by 1 is my signature. That statement itself is not there. Now the only thing remains is whether the IO has proved her signature. 104. IO is 89.
104. Let us,
84.
let us see the magistrate statement page, there's a PW 48, 291. Who recorded it?
291.
291. PW 48.
PW 48 does not refer to.
No, sorry, but that is, sorry, I'm actually sorry, but that is 49, Madam, sorry. 49. 293. He says 104 by 3 and 104 are the signatures of witness, Miss Amosa.
But can this be done?
Huh.
Can this be done?
The matter, period 49.
You see, you have seen us from 10, 15, we are both sitting here. Correct. We also have experience how affidavits are notarized by the notaries. Now, somebody, two people go to a notary and get a statement recorded before a notary. We both are here, but our statement has been recorded. There's a affidavit drafted on my behalf and on behalf of my brother. My secretary is here, my court master is here. All four statements are recorded. And then the notary comes in the witness box and says that no, this is the signature of A, B, C, D. When we were examined, we said that 104 does not contain my signature.
But let us accept it that way, madam, her statement, because she has denied everything. He became hostile and I have prosecuted her. Now, in that state, when we have produced the magistrate who recorded her statement,
No, that's what we are saying. We are here. From 10:15 we are here. But somebody notarized in our name an affidavit.
it's not a notary, madam.
No, no. You see, it's a magistrate, it's okay.
He,
But magistrate does not know their identity when they are recording it, because we have seen in our experience in trial court. The police produces a witness, the magistrate says, okay, the usual pattern is Kinam, so and so, okay, Gokiman, so and so. Then magistrate will check from the production memo. Okay, same name, so and so. How? Then records the deposition.
that is a quite different part of it. Of course, that what your lordship.
But the witness who
No,
comes,
I-
who
I
says,
accept, but it happens. It's not that.
no,
it
no, the witness who comes, she says that it doesn't contain my signature.
She
But
lied
then
all-
you see, then,
She
the-
lied all the way.
no,
She lied her.
no, that is
full
okay.
She lied,
You see, we say it for a lawyer.
no, not lied, or we can say that, she denied.
Well, let me say something. No, not that. You see, when it comes, I have seen, it's in a celebrity comic book for lawyers, where there is a epitaph of a lawyer in a grave, and the epitaph in the grave reads like like this. Here lies a liar. He lied all his life, and he is still lying. It was in a comic book, what do you call those, Advocates Classic comics, and it is mentioned there.
Similarly, there is another story, Manu. Then there were three friends, great friends. So what was the like? The other businessmen, etc., and all the things. Then one of our friend died. So all of them, they became criminal. So in the condolence, that is, his coffin was taken, Christian mother, not in our country. So what happened, mother? They thought that they will contribute something. So they decided in a meeting that they will give so much of dollar, etc. Now, this lawyer, he said, okay, it's fine with me. He gave a check and put it in a coffin. Now, in his death.
So,
Happens,
so you see,
as your lordship has said, Manan, here lies the lawyer.
now you see, what we are trying to say is that when the witness comes, he says that it is not my signature. So normally that signature would have been sent for forensic examination to compare that this is the signature of so and so. That was not done.
That one part also. No. Anyway, what your lordship has.
No, there's another aspect. You see, a signature can be otherwise proved by an expert.
Yeah, like.
So expert was not there. So therefore, opinion as to the handwriting is not there.
No, that is not there. Anyway, but expert was done, but only your lordship has to dispense with this magistrate Palon, PW 49, who says, let us see. If your lordship believe PW.
No, we believe everything. It is only in the analysis we made,
What?
we may go here and there.
What are, if your lordship believe this,
I'm for a moment not saying I'm not believing it.
No, no,
I'm
no.
believing it.
that she says.
But how I
nothing has
appreciate
been
is,
signature. Now, the message comes. He says that. Oh, your lordship, page 49, PW 49, page 293, just one paragraph, my lord. On 11/1/2011, I was working as judicial magistrate, first class Impal West. On the same day, one witness, Miss So-and-so, Wamsa, aged so-and-so, Impal East.
before you read this, only one thing. You see, your previous argument was that once an evidence is led and no objection is raised, you have cited 2007 saying that 2017, it is saying that then it can't be undone. Now, please keep that principle in mind. You see, this witness, when she was there, she said 104 does not contain my signature. At that point of time, you see, she was a hostile witness and she was being cross-examined by you. You did not put to her that, look, 104 by 104 contains your signature and this is so and so. But here, what this magistrate does is in page 49, PW 49, she says that I have opened the envelope. We find their statement there, and her signature is 104, 3 and 4.
Yes, Mother, yes, correct. She said, exit 104, statement recorded.
Last line is does not contain my signature.
But I do not remember as to how I have given to the mail.
No, last line in the cross. Next page.
Yes.
Last line in the cross.
That is what she said. Mother.
Hmm.
No, just come to.
Yes. I'm just saying that keep that in mind and then you make your submissions.
Exhibit 104 is a certified copy of statement of so and so. Exhibit 104.5 are my signature in the certified copy. Today, after opening the seal cover or seal envelope, I have seen the original exhibit 104, which is also marked as exhibit 104 by 1. Exhibit 104 by 2 is my signature. Exhibit 104 by 3 and 4 are the signature of so and so, which are put in my possession. That's all. That's all. The cross of this witness, my lord, is at 295.
On the next date,
On the next date, Mr. Das, referable to this PW 49, you also have to address us on one more issue. Now you see in somewhere in this statement, this magistrate PW 49, she says that so far as I remember, the evidence was given in Manipuri and I translated into English. That's what somewhere he says.
Yeah.
Now, if you come to page 402, that document statement,
My lord.
page 402, this is volume. This is volume 2, part 2.
My lord.
Just come to that document.
My lord.
You got the document, 402? You see page 1, page 2, 403, 404, 405. Correct. Now, this ROAC is written in the left side without any signature. The magistrate signature is in the right side. So therefore, he does not
Hello.
he does not say that it was read over and explained and accepted to be correct. I don't know, in a paper, it is on the left side. What implication it has, we don't know. You'll have to address us on that. Because it is normally below this ROAC, read over and explained and accepted to be correct. It is after that normally a signature is put. And in her statement, she doesn't say that I think he has said that somewhere. In 9. Explained. She said he is explained. No, I'm looking at something else. You see, I don't know why it always comes to my notice. This statement you'll find it very interesting. 294. Before that cross-examination, last 4 lines. As far as I remember, he spoke in Manipuri and he spoke. She's a lady, but
And I did.
he spoke in Manipuri and recorded in English. After recording his statement and getting it printed, I explained it the same to him. She's a lady, but
Today,
not only this, there's a gender change.
Okay.
So next time you'll have to address us on this also, how this ROAC has to be dealt with, because it doesn't have the signature. Signature is of the NIA court. We'll continue tomorrow then.
very well. Can we just look at, to have a glance at the.
Definitely.
And the original.
Concom Hindu Bhushan, he is a male,
Who?
294. The paragraph starts.
No.
before the
PW 48 is a lady.
48 is a lady, but which the magistrate is saying that I recorded his statement. He spoke in Manipuri. That is his Concom Hindu Bhushan, not a lady.
Not very, not a.
Lady,
This part is only, yeah, 293,
294.
293. That is a one.
Okay,
Because
okay.
He recorded, 1, 2, 3, 4 statement, mother.
Okay. Oh, I did not know that. Okay.
I thought that he also wanted to say. We'll continue tomorrow, mother.
In respect of PW.
No, but then in
47,
PW1, this PW 48, it does not say that it also says, I explained the same to her. Okay, I explained the same to her. I recorded in English. After recording a statement and getting it printed, I explained the same to her. Exhibit 104 is the certified copy of the statement. 105 and 106 are my signatures. After opening the seal and seeing the original of 104, this by 105. Signature 103 for signatures of witness. Sorry.
Oh, I took this in.
I did not record. Very interesting again. Very interesting again. Page 295.
Yes.
Yes. I have not recorded in Exhibit 104 any statement as regards what procedure I have applied while recording the same. There are two copies of Miss Wangke Mayum Amusana, which were recorded under section 164(5) of CRPC. In the above two copies, the statement are same paragraph by paragraph. In said one copy, I have signed only second page, not in the first page. And in the second one, I had signed both pages. In one set, in one copy, Miss Wangke Mayum Amusana has not signed,
The second-
and the second copy is signed one. So therefore, when you are showing that copy to PW48, she said it doesn't have my signature. But then you produce a second one which contains a signature. But two copies of statement itself.
What was the message?
Go by the record.
That's true, but once we read, we find so many things. Does he? The original Saudi. Original is like Saudi. Listen, okay? Saudi.
Mother. Just on this reference, mother. It was disposed of on 2012-22.
Okay.
Even a customer, they can find it, find the judgment, mother,
Okay.
in a website.
Mr. B. Prasad, Mr. Rashekar, learned counsel for the appellants, and Miss L. Devi, learned counsel appearing on behalf of the learned DSGI are present. First of the submissions of Mr. D.K. Das, Senior Counsel, assisted by Ms. P.K. Darji, learned counsel remains inconclusive. Next para. The learned senior counsel for respondent number 2 has referred to order dated 28/6/2019 passed by this court in IA Criminal 71 of 2019 arising out of this appeals, and it is submitted that the TCRs were sent back to the learned Nia court. However, by now, the trial of one absconding accused
On 2012,
has concluded on
2012,
20/20/2022. Full stop. Accordingly, it is submitted that the original TCR may again be requisitioned.
at the earliest, that is by,
You have no objection, I believe, huh? The said prayer, next para, the said prayer, not having objected to, stands allowed. Not stand, you say is allowed. Is allowed. Next para, the registry shall send a requisition for the original TCR. Of the learned special judge, Nia, shall send the TCRs as early as possible. Next para. As the matter is being heard on day-to-day basis, list again on tomorrow, 22. Now, this Prasad. There's one more thing I missed out somehow. Mr. Mishra had referred to paragraph 14 and 23.2 of Arup Bhuiya 3. And he has made, he had submitted about the meaning of section 20. That context I somehow missed out. I've made a half recording in that. Para 14 and 23.2 of Arup Bhuiya 3. And reference was made to section 20 of UAPA. But I forgot the context. The statement I have missed out. That is one. Second is the return of loan
Loan is a
within 14
paragraph
days,
55. That's in
you said that in the judgment,
paragraph
paragraph 55. Can you please come to it so that we can close that.
relation to the statement made by TW 23 and 24.
Just hold on.
Paragraph 54. Page 974 of the matter. Part
54. Yes.
TW 23 had made a statement that Aegis applied for a loan of rupees 50 lakhs, which was sanctioned by the bank on 30/7/2005 against 3 term deposits, of which the party submitted into the bank of rupees 25.
Oh, just a moment, I'm missing it out. Paragraph 54. Yes.
Like how it has been wrongly recorded, we have to come to
Huh.
TW 23 first.
PW 23, which is that page?
Page
What?
2,
Page
triple,
222,
volume, volume 1.
volume 1. Yes,
The last paragraph.
yes.
Aegis applied for a loan of rupees 50 lakhs, which was sanctioned by the bank on 30/7/2005 against 3 term deposits, of which the party submitted into the bank for rupees 25 lakhs, 20 lakhs, and 20 lakhs, and in all 65 lakhs for securing the loan. The party thereafter repaid the full amount of the loan on 16/8/2005 by adjustment of the term deposits within a period of 40 months. Now, how it has been recorded, madam, in paragraph 54, madam, by the bank. Last 4 lines, madam.
Of paragraph 54.
Making a huge.
Just a moment.
Yeah. And that is appreciation, not a.
Yes,
The last 4 lines, madam.
the fact of taking a huge loan,
And repayment of the same within a very short period was really unusual. And spoke loudly about the extreme financial soundness of the firm. Whereas they had given the term deposits and which was liquidated.
But that is how he has appreciated.
no, I have missed out certain parts. Therefore, I'm just asking for filling up those gaps because we don't want gaps to remain.
Take of PW 24. Page 2 to 4. Pass one, 1. PW 24.
2 to 4.
2 to 4. Second last paragraph, last 5 lines. I found that some of the contributions. Here use the word some of the contributions were not supported by proper documents. It has been recorded by the trial court. at page 975 of the judgment. Nine 75, fourth line. The witness.
Yes,
further
sir.
stated- The witness further
Just a
stated
moment.
large amount
Just a moment. Para,
say 54, then 53, 975.
para
Fourth
52,
line.
huh?
The witness further stated that large amount of contributions were not supported by documents.
Okay.
The witness says bigger amount. The witness says bigger amount. The Sergeant Judge says large amount.
No, we are only spending our spare time reading this. Because you see, what is required of a judge is that justice must not only be done, it must seem to have been done. So this part is the second part. Seem to have been done. So therefore, you'll go home with an impression that at least we are hearing you and recording something. When known faces are there, I can't help smiling. I create a situation where I can smile, only that much. I create opportunities to smile. There's nothing more.
Supplementary cause list, single bench, item 1, IA 32/24 in WPC 114 AP 2018.
Please, your lordship, not on behalf of Syed Sheikh, your lordship. Kindly cite for correction of the order. Page 8, lordship. Immediate player, lordship, the time of player, lordship, liberty was not served.
Chaudhary was here. Kakadi Chaudhary. Just have a copy of this. It's concerns Union of India, Arunachal matter, but concerns Union of India.
Oh.
Non-payment of salary for 26 months.
Has not been traced. That is creating the problem.
No, you see,
Payroll has not traced.
if
But if he
if-
has, it's not, that liberty he should have.
no. There's a reason for this. Perhaps because I won't recollect after so long. It's come after 2 years, I won't remember. Now, here what has happened was, he says that he has not received his salary for 2015 to 17. Writ petition is in the year
18.
18. Then there are departmental proceedings going on.
But then,
What has happened to the departmental proceedings?
Lordship, can I, your lordship's attention?
Because here what has happened is there is some litigation in another court, in Rajasthan court.
Just for a moment, if I may draw your lordship's attention to paragraph 5 of this page. So he has gone on compulsory retirement. If he has gone on compulsory retirement, he will be getting some.
No, I'm not on that. You see, if I'm presiding the bench and I'm not given that liberty, there must be compelling reasons to do it. I'm trying to find out one. Correct, because you see, come to page, you have a copy of the writ petition, please give it to the DSGI. This is the writ petition. Come to page paragraph 7 of the writ petition. Petitioner agitated transfer, he was subjected to harassment, and he subsequently reviewed petition authorities before the Honorable Guwahati High Court. Sorry, Rajasthan High Court.
Lordship is referring to paragraph
7 at page 9.
This petition is not here, lordship, but also he's online lordship.
Okay. Yes. Yes. Where is, you are there? Huh. You are getting us? Please unmute yourself. Unmute yourself and make submissions.
If it is
For
your
this,
lordship,
for this time when you were not paid salary, have you produced any document that you were attending your duties? Or where is the document to show that leave was granted from the concerned during the concerned period of time, 2015 to 17, that you were granted leave? Is any document annexed here or in the rate petition?
lordship, what of the regarding the writ petition, your lordship? My senior IK Soika is there. What already everything
It does not
documents
have a
there
copy
with
of the
the
writ petition. It does not have a copy of the writ petition. Okay. No, Mr. Sayyed, we are not questioning anything else. But if this bench is not granted any leave, that means there will be some compelling reasons. Because you see, instead of it has happened many times that instead of getting an adverse order, they say we withdraw it, and it's withdrawn. So this way we are searching for. Because his service career is not very impressive. He was penalized 3 times during his service career, including reduction to lower scale of pay for 3 years by Chief Engineer Project. Just to counter that, what you do is that you file writ petition against the officers alleging corruption. Because it is during that time, 2015 to 17, there are departmental proceedings that are contemplated against you, and then you were absent. Because after so much a long time, I won't remember. Now I get it. Why it was withdrawn, now I get it. You see, the petitioner went to Rajasthan High Court. From there, some order passed for the petitioner to join at the place of place where disciplinary proceeding was to be instituted. Then because of that order, the BRTF had no other option but to transfer him to that place. Then he raises a grievance that where disciplinary proceeding is to be instituted, why I should be transferred there? And then he did not attend.
But that was at his own request.
Huh?
That was at his own request.
That's the order of the court, but at his own request, but we don't know what is there, because after 2 years I won't recollect everything. At that point of time, things are very clear. And there was a direction, and the High Court orders was passed in 2017. So there is a gap between 15 and 17. So if you will have to show that within that period there was a leave. I think because of that it was withdrawn. We'll take it up next week then. We will give him a week's time, because you will also require the records.
Yes.
I'll tell you why. I'll tell you why. That's it. Choti Sabha. Just say, Mr. I.S. Sekia, counsel for the applicant, is present. Okay, and Mr. R.K.D. Chaudhary and DAGI. Sit together, so and so are present. Both sides submit that the copy of the WPC 114 AP of 2018 are not available with them. So accordingly, matter stands adjourned today. List on. You agree to a date, both of you? You take it up on Friday? By then you will get it?
Friday will be first.
Friday will be 1st March.
Yes,
You'll get instructions by then?
has to come from, I'll just check out.
This is again no difficulty on 1st?
Worship, I'll try to. Oh, it's, Monday.
Okay. 4th then. 4/3/2024. But since I come from the other complex, Order 23 Rule 1 and leave under Order 23 Rule 3 is always in the mind. So if I'm not giving it, there must be some compelling reasons. Pardon me? No, I don't know. I won't remember, because I don't have the track. I won't know it.
Has been quite some time.
Huh?
Has been quite some time.
Memory power is very,
Pardon me?
memory power is very strong.
No, absolutely not.
No,
Absolutely not.
that is perhaps coming from there. Perhaps doing practice in the civil side, Lordship, that.
No,
Mr. Chaudhary, not that. You see, 26 years, reading only one book. So memory is not strong. People pass out LLB by reading Allahabad series for one time, just before the exams. Correct?
15 days.
That's what I'm saying. So with that background, if I'm reading one book for 26 years, definitely I don't have a good memory.
if you're, it's just out of this context, if your lordship will remember, lordship appeared in a case relating to Paltan Bazar at one point of time. Relating to Paltan Bazar at one point of time. And I was a counsel opposite to your lordship. I had a very tough time. That matter is still good.
Still going on.
Execution.
No execution. Okay.
But I am no longer there. Corporation.
It's okay. So God successfully handled few matters. Successful or unsuccessful.
But it's-
26 years is not a good, what do you call? Yeah, nobody can say it's a good memory.
Very. Very clever.